Hello, everyone. My name is Ashley Flores. I am with the Cornerstone Group over at Team Zingali's Realty. Today, we are here with Liz Barletta with Ligris and Associates. Hi, Liz.
Hi, how's it going, Ashley?
It is going great. Another snowed in day for us in real estate.
Oh,
Definitely just making the most of it. So we are here today to talk about the attorney and the role that the attorney takes in the home buying transaction. So, for example, as your realtor, I would technically be introducing you to the attorney once I know that you have the pre-approval. So we've already done the buyer consultation. We sat down, we discussed the criteria of what the buyers are looking for in their home search, and they received a letter of pre-approval from the lender. Now I am going to introduce you to an attorney such as Liz Barletta, and this is going to help you establish a relationship with the attorney involved in the transaction because we do need an attorney. Why do we need an attorney in a buyer transaction?
yes, great question. So, just to step it back a little bit, I love the fact that that is your process for your buyers because for buyers out there who are listening, isn't always the case. Oftentimes, the attorneys are introduced in the transaction once an offer is accepted. But as you can imagine, so much happens once an offer is accepted that it's incredibly overwhelming. You have to schedule an inspection. You have to check with your lender. You just are under contract to buy a home. Like it's very overwhelming. But then to hire an attorney on top of it, usually people have not hired an attorney at that stage of their life yet. So it's kind of like an overwhelming experience if this is added in at that moment. So I love the fact that you set up your clients in such a way that they have their pre-approval ready before they've even gone shopping. They know who their team is. And that is literally, I think, the best way to handle it because then they can have that conversation with me. I can explain like what we'll start explaining here, where I'm involved and why, and all those answer all those questions. So the moment they have their offer accepted, they can just know that okay, Liz is going to start working on the purchase and sale or whatever. So super like I love that about you.
Yeah.
So besides that, the question why is the attorney involved? So in Massachusetts, our legislature has found that the closing of a loan and the closing in general is the practice of law. So for those of you who are maybe from a different state, even maybe in New Hampshire, though most states in the U.S. actually have title companies handling the closing. They could be owned by attorneys. Maybe the person who works at the title company is an attorney, but you don't have to have an attorney in those states. Those are called title states. We are in an attorney-led state. So in Massachusetts, you have to have that attorney essentially take that integral part of that transaction where we're researching the title and issuing a commitment to you as the buyer that the title to the property is clear. That has to be handled by an attorney because again, it's considered the practice of law. But maybe to kind of talk about what that specifically means and on the buying side of the deal, there usually is up to two attorneys on the buying side of a transaction. So you have, if you're financing, you'll have your bank attorney and then you'll have the buyer attorney. So for a lot of people, they say, well, I talked to my cousin and he had one attorney. And that's because the majority of the time, we usually act as like a dual attorney, where we're handling the closing for the bank, but we're also representing the buyer's interests in the transaction. And we have this dual role, which the Massachusetts legislature has found to not be like a conflict of interest because our goals of the buyer and the bank are so aligned that we're able to conduct that sort of dual role. So for a lot of people, they're like, wait, two attorneys, one attorney, what's going on? But usually it's because that one attorney is handling both roles. That makes sense.
Yes, awesome. Another great reason to have an attorney in your corner early in the process of the transaction, I feel, is when I am writing up offers, a lot of the time in those contingencies in the extra verbiage that we have to include in an offer, like, and say with the inspection or, if there's something on the property that you want to add as a contingency in, your offer, we would have to consult with an attorney for proper legal language to add into that offer so that we're covering everyone's behind and we're not saying things that can potentially you know ruin the offer and just totally destruct it. So what do you think?
Totally. So when you as a consumer out there who are listening, the offer has, fill in the blanks for those things like closing date, purchase price, all that. But then there's a section called additional terms, and it's like
Mhm.
blank lines. So if you're adding these additional terms, you're relying on your agent, and that's a lot of responsibility to be put on your shoulders. So I love the fact that we collaborate often on that extra language because what I always encourage my agents to do is like, text me what or explain to me what you're trying to say. And sometimes the language is perfect. It's like, yeah, that works. Exactly what you wanted to say. But sometimes it's a matter of changing a word here or there, like adding a little bit extra. And it's so important because once that offer is accepted, that's a legally binding contract.
Mhm.
Buyers have been found to actually sue with just the offer and win in court without having to go to that secondary purchase and sale agreement. So, super important to make sure that whatever you want in the offer is exactly how you want it worded. And because also oftentimes, depending on what your type of market you're in, if you're kind of more in a seller market or buyer market, you may have an attorney on the selling side where they have lots of buyers that are lined up for this property. They may not want to start negotiating the language that was already accepted. They're going to say, no, my seller accepted this offer. That's the language you have. And so if it hasn't been potentially looked at by an attorney, you're kind of stuck with maybe language that isn't as, helpful or protective than you could have just by asking that attorney prior to. So you always do it the right way, which is awesome. But definitely that is such a benefit of being introduced early on. So that way we can give that feedback.
Perfect. Yeah, I know that a lot of the times there are things like a gap appraisal that might need some attorney language, and there are things, with the inspection after when you want to submit like a counter offer that might need attorney language.
For sure. And one thing that we see a lot now, especially when you have transactions that were what we call like domino closings, where you have a sale and a purchase, maybe you're negotiating what's called a use and occupancy, where it's kind of like where the seller is, or the buyer is either moving in early or the seller is staying after closing for a period of time.
Mhm.
And if you're not necessarily putting in there the price that you're going to be charging the seller, the amount of like a holdback or like a security deposit, if you don't put
Mhm.
that stuff at the in that offer, later it just makes it harder for the attorneys to try and get that seller attorney to agree to a reasonable holdback and things like that. Whereas if the agent's already put it in, use and occupancy for this amount of rent and this amount of security, then
Mhm.
there's no question and pushback from the selling side. So
Right.
definitely something we're seeing a lot more these days with these kind of double closings.
Yeah, especially because inspections have changed now.
Mhm.
And so, you've always had the right to an inspection, but now it's not like you can include that in the language of an offer where, yeah, we're waiving an inspection,
Right.
so it's important to have the attorney to be able to kind of back up your offer and just building that strong team, right? We network with one another so that we can establish a circle of trust with everyone that's involved in the transaction. So, building that team from the beginning, having that buyer consultation with your real estate agent, and then, getting the lender involved, getting the attorney involved, making sure that you have someone that's going to be able to insure your home. These people all take a part in closing on the transaction, and getting everyone involved early in the process, I think, is going to call for a smooth closing. We don't want any surprises at the end or, missing pieces because of that. So that's why it's important to introduce the attorney early on in the game. Also, most of the closings take place at the attorney's office, don't they?
Yeah, exactly. So it's funny, sort of post-COVID, pre-COVID, I was as a closing attorney driving from Suffolk County Registry of Deeds to Middlesex to Essex North to all over the place because transactions generally were always closed at the Registry of Deeds. That's just how it was. But post-COVID, most of the registries or all of the registries started using the format of electronic recordings. So the beauty of closing at the office is that in the event that there's some document that sometimes things happen like an hour before closing the lender's like, oh wait, you need to actually have this document signed. Well, if you're at the registry of deeds or in the car on the way, like, how are you going to get this printed? So I had friends in all the registries that would kind of like print things for me when they're not supposed to, but like it was just an added stressful experience. And
Yeah.
sometimes you wouldn't be able to go to record right away because you had to submit a scan of all the closing documents, which is to get funding approval. So basically, some lenders require that they actually see every single document that was signed before they say, yes, you're okay to record. And so closing obviously outside of the at the registry of deeds and outside of the office, that meant that we would have to drive all the way back to the office, scan it, and then submit it or courier it back. Like it was a challenge. So
Yeah.
having closings now at the office is just a lot more efficient, and I mean, I love it. Driving everywhere. It's
So, we're getting to the closing table. We've signed all the paperwork. Can you please elaborate a little bit more on why it's important to be on record before entering into the premises of your new home?
yes. So for us as attorneys, everything's about risk allocation and being safe and making sure. Well, first of all, the contract generally is going to require this. But on top of it, the reason why the contract will require access only after it's on record is because, let's say something happens, you enter the property, someone gets hurt, who's responsible? Well, technically, pursuant to the contract, you weren't supposed to be in there. And so whose insurance is covering it? Well, the insurance denied the claim because you weren't authorized to enter. So lots of different questions can come up. So the safest bet is always to not enter until you're officially on record. And what if on record really means is once we have signed all the documents, there's a deed. The deed is what transfers the property from the seller to the buyer. And that document has to get submitted to the registry of deeds. Nowadays, it's all electronic, so you submit it, and at a certain point, that deed will get recorded. But depending on when it gets recorded, that's why we always try and encourage potentially not closing on a Friday because maybe there's a lot more people trying to record that day. Maybe not close at the end of the month. Like the last day of the month is notorious for being one of the busiest days for the registry, getting all those submissions. So maybe picking the day before and just having a backup plan is what we always try to recommend our clients because let's say we don't make it to record that day. Well, then if it's a Friday, especially, you have Saturday and Sunday both that will pass. Maybe that opportunity that you wanted to move into your new home has passed. Maybe you have a moving truck filled with stuff that now you're going to have to pay to store for that
Yeah.
period of time. So having that flexibility and understanding that until it's on record, you can't access. There is also the potential of negotiating this. So like if you have to close the last day of the month, like that's it. That's the only day you can. Well, at the onset, when you're submitting your offer, you can maybe ask for the use and occupancy, where the seller's allowing you to move in the event that we miss the registry cutoff.
Yeah.
So that's all stuff that should be talked about. I know you do a great job with again, having that buyer consult where you can understand the requirements of your buyer. So that way we could put that language in the offer to make sure that worst case scenario, we don't go to record. We have that use and occupancy protection. So that's the recording requirements and why it's important.
Those are some really great valid points. I appreciate you taking the time to explain that to us. Another great strategy that I often hear is closing before 11 a.m.
Yeah.
And I think that also has to do with recording matters, right?
Exactly.
Yeah.
Because depending on the registry, the submission, it seems so silly. Like you have a business day that's until 5 o'clock, but that's not how long the registries are open for recording. They
Mhm.
accept submissions. Sometimes the cutoff is like 3:15 or 3:30 for e-recording submissions. They may still be recording towards the end of the day. Maybe some registries end at 4:15, the recording hours, but you have to submit by a certain time. So
Yeah.
if you miss that recording submission and cutoff, then the likelihood is you're not going to record. And so having, closing by no later than 11 or 12 o'clock, that gives you the, 3 hours potentially to submit those documents. And also keeping in mind that in the event that I kind of touched on it when we were talking about recording outside of the office, where it had
Mhm.
risk where some lenders require funding authorization. Well, if your lender requires funding authorization and we close at 1 o'clock, let's say, well, we have such a small amount of time to get approval from the lender to record and submit the
Yeah,
documents. So definitely having the closing at the earlier part of the day gives you the greater chance of making it to record to be able to gain access, but definitely always recommend potentially trying to have that backup plan if you're not flexible. If you have to move in that day, you need to communicate that to your agent so that way we can plan for it ahead of time.
fantastic. Well, there you have it, everyone. This is the role of the attorney in the buyer transaction. Thank you, Liz, so much for sharing. I do appreciate you taking the time to come out and explain to us what your role is in the buyer transaction for a new home.
Nice
And
to meet you, Ashley.
yeah,
Thank you for having me.
I appreciate it. Yeah. So there you have it, folks. If you are looking for an attorney to close on your new home, Liz Barletta is happy to assist.
Absolutely. And I will hopefully see you on another video soon.
Yes, thanks again. If anyone has any questions that they would like more, comment in the comments below and we'll be sure to get back to you.